She's texting him.
All right. All right, we're going to gavel back in and resume our conversation on House Bill 853. Is there further discussion on House Bill 853?
Well, since we're, House Bill 853, I don't know if it has a Senate cross file, but I don't see any position from the state's attorneys in the file. My staff indicates it was an unfavorable, they were signed up unfavorable in the House, but they're trying to see whether that was just oral or written, but my staff's pretty good about putting written testimony in. So the short question is, do we know the position of the state's attorney on House Bill 853, I guess now, or as it came in or as it was amended? Is it?
They have the States Attorneys Association filed an unfavorable.
I can't hear you, Mr. Chairman.
Yeah, sorry.
Sure.
You got it. That's right.
So on the House bill, they filed an unfavorable. I'm looking now.
Does it look like it was just oral or it was written?
It was written.
It's dated February 14th.
3/14.
February 14th.
February.
I'll print it out for you. Schellenberger.
God damn it. I'm the taxes. This is ridiculous.
Senator James.
Thank you. Thank you.
Oh, that's right.
Oh, okay. Huh?
That's what I just brought up.
Well, how did we miss that?
I don't know. I should have been in there.
Yeah.
So, again, I'm trying to catch up here and do some things. I know I asked counsel on some of the descriptions for the sex offenses under 11-701, which then you, as were stated, we then have, it references us to several other locations in the law of actually what those sex offenses are. So, like, what are those enumerated sex offenses so that we have an idea of, because as we're well aware, in the crafting of some of these laws, it'll say one thing in the title, but the subjects of each one is not necessarily encompassing of what the title says. It goes other ways. This is wonderful job security for some. But go ahead. Can you answer some of those, please? or as best you have them, and I appreciate you looking them up. I know you spent some time looking that up.
Thank you, Senator. So sex offender under 11701 provides that it is a person who has been convicted of an offense that would require the person to be classified as a Tier 1 sex offender, Tier 2 sex offender, Tier 3 sex offender. Now, sort of here's the cross references. Tier 1, 2, and 3 sex offenders are defined also in 11701. And there's an extensive list of offenses that would qualify a person for each of those. But
I can't.
sorry.
I can't hear you. I can't hear you.
That's how I work.
Okay, thanks.
Sure. So there are about, well, it's for Tier 1 sex offenders, it's a mix of state and federal crimes that would qualify a person as a Tier 1 sex offender. That ranges from 4th-degree sex offense to visual surveillance with prurient intent, child pornography offenses. Let's see.
So that's in,
That's in Tier 1 sex offender.
so I want to be clear, that what you're saying is that under the sex offender, which is inclusive of this, not exclusive, right? I want to be clear that this is one of the things that's covered under this.
No, actually, it's the opposite.
They're out.
So they're not included.
Right, they would be ineligible to file a petition, Senator.
You cannot if you were.
Okay, so that's what I meant. So they're not, they would be a portion of the group that would not be eligible
Correct.
for
Right.
this look back.
So those people and people who had received a sentence of life without the possibility of parole would be ineligible.
Okay, so again, so that kind of brings me to my point here, is that, so, and I'm not, believe me, in no way, shape, or form am I justifying, I think child sexual predators and those people should be put away and the key thrown away. No doubt. Having said that, when we're looking at, so they get no look back, so they're not able to be reformed, is the reason that they're not getting a look back.
I couldn't speak to the.
Well, I know,
the
you can't
House's
speak to the reformative part of it, and if they don't, however, by this language, they don't get a part of this look back.
That's right.
They're correct, they're not included.
Okay, nice. The people that commit the most heinous crimes, rape and murder,
Well, rape would be a sex offense.
okay, all right, murder. So we have rape where someone is raped and that person goes away and isn't eligible.
Right.
If there's, so in cases where there's a homicide and a rape, like the one in Harford County,
Right.
and a lot of times in cases in a plea agreement, what will they do? They will plea out the lesser charges, and they will take the higher sentencing guidelines. And then if you plea it out, and so thereby there's not a conviction, but the homicide is on there, could that person be eligible for parole with this, the way this is written?
So there are certain homicide offenses that are.
Oh, I'm not even just talking about the homicides. We'll get to that in a minute. I'm talking about, in the way this is written, someone like in Harford County, the very unfortunate incident, rapes and murders a mother of 5 as an effort to ensure the conviction, because things are difficult at times, apparently more than we want. The state's attorney agrees to a plea bargain. The guy will take the homicide charge, and as a part of the merging of the charges, or whatever you want to say, they'll plead to that, and everything else is put away, like, not
so
on the stat,
just-
I guess, or what, but.
Sort of how I'm hearing the question is, those offenses that if the person were convicted of them, they would be required to be a registered sex offender. However, through the process of either pleading, well, it would be
adjudication.
through the adjudication process.
There's no conviction.
They were not convicted and therefore are not required to register as a sex offender. Would they still be eligible? And the answer is yes, because, I mean, they wouldn't be a registered sex offender.
So that's one point I wanted to make, and that's one problem with this. The second one is, so we have people that are, and this is only for 18 to 25-year-olds. And I guess I should ask for clarity, is the 25 encompassing of up to 25, or is it up to 25, 364 days? Because it's a shame we have to get into semantics. Huh? Younger than 25. Okay, I'm sorry. Thank you. Thank you. Younger than 25, so it's up to 25.
24 and 364.
Okay, so we have this, that we're saying that this group of people should get this look back. If you commit a homicide, and I'm looking at recidivism rates, I'm looking at a testimony right now of one family who, in 2018, his sister was murdered by her own son, and that he got sentenced. The judge didn't want him to have life. The judge sentenced him to 80 years. So 40, because it's a crime of violence.
40 for parole eligibility. because
Parole
it's
eligibility.
Generally 50.
I'm sorry. Yes, I apologize. Thank you for clarifying. If you get sentenced to life, what is a life sentence in Maryland, and what gives you the opportunity on a life sentence? At what point are you eligible? Like, by the sentencing guidelines for a crime of violence, because life usually is a crime of violence, or has to be. So what would be the current look back or the current first time eligibility for parole?
So under Title VII, Subtitle 3, the Correctional Services article, there's a list of eligibility periods for parole. For a life sentence before October 1st, 2021.
Hold on, October, I'm sorry, hold on. October 21.
So for eligibility for a life sentence before October 1st, 2021 was 15 years or 15 years inclusive of DIM credits. After October 1st, 2021, it is 20 years or 20 years considering DIM credits.
Okay, so after 2021.
And I also want to point out that there is there's a possibility where if the state sought life without parole, but didn't actually obtain life without parole, and the judge sentenced that individual to life, under this provision, parole eligibility wouldn't occur until 25 years.
Okay. So just again to clarify, and thank you for that. A life sentence before October 2021, you would be eligible for parole, even if it was a homicide?
Well, yeah, and
You could be eligible for parole in 15 years.
right.
And then you said something about 15 years. Did you say inclusive, exclusive of DIM credits? I didn't hear that. I'm sorry.
Right. So that also includes the consideration of DIM credits. So
So you can't go below 15 years, but you could get, or could you go below 15 years?
right. So it includes considering DIM credits. So let me just pull up the exact language for you, Senator.
Mr. Chairman, I'm sorry, we're trying to, I wasn't here, and I want these answered.
Just, and then just make clear, like, that's if you were to max out on them, right? It's like you.
Yeah, if you're maxed out, that's, yes, thank you, because that's where I'm going.
So Alexis is currently failing me, but right. So if you were to max out on DIM credits, the earliest is generally considered to be around 12 years.
So with a crime of violence, which homicide, you could be eligible currently if you were sentenced to life before 2021, October. You could be eligible without DIM credits at 15 years, or with dim credits as early as 12 years.
Right.
So after 2021, October of 2021, if you're sentenced to life, even for homicide, which is the sentencing guidelines, it would be 20 years, and there's no consideration of dim credits?
No. It does also consider dim.
Okay, so what would be the soonest you could get out with dim credits?
I'd have to look, but I'd estimate probably,
17,
I think you're probably looking at 15 or 17 years.
15 to 17 years, somewhere in that area? So my question then becomes, we're talking about the most serious offenders already eligible to be out in, if they were before 21, 12 years, after October of 21, 15 to 17 years. What are we trying to solve with this bill, Mr. Chair? Like, I don't understand what we're doing here. It looks like, by the way this is written, they're already getting a considerable, a pretty generous thing right now. Am I missing something? Please, I just need somebody to explain to me what I'm missing as to what we have now and what this bill is trying to, because this is not a victim's rights bill. Let's be clear. This is a bill about reducing somehow a sentence and getting a look back for people that shouldn't be getting look backs as homicide suspects or convicted homicide, convicted murderers. So I'm unclear on what this does, because now, here again, I'm going to reference back to this homicide where the judge referenced and sentenced to 80 years. So is there anywhere in this that's going to require any, like, are judges just going to be able to then, are they no longer going to be allowed to sentence up to 80 years? Or is it only going to be life? Are they going to be able to sentence?
No, so this allows, and I'll let Senator, this is Senator Sidnor's bill, so I'll let him speak to it, and I can speak afterwards. But,
Okay.
I mean, just understanding that this allows for another judge to take just another look at this sentence, reviewing all the case file, all the facts, everything there. Obviously, the victim impact statements, victims can participate in that process, and that all of that information still gets weighed and valued into a decision. So
Wasn't that already valued in the first decision?
100%.
And isn't it valued in each appeal subsequent to that?
It's always a part of the process.
So is there anything that says once appeals are exhausted, they can get a look back? Because they're getting appeals along the way. Was there any consideration of that? Because, I mean, this is just another slap in the face to every victim in this state and their families. This man thought once he buried his sister that because the judge didn't sentence to life, which was a blessing, because apparently the dude could have been out in 12 years for taking another person's life. But this now, and because he got sentenced to 80 years, he's not eligible for 40 years. But now this would give him a look back. Thank you.
Thank you. First, I mean, if I'm hearing you correctly, you seem to be concerned about the amount of time that someone is incarcerated. But again, to become even eligible, you would have had to have been in prison for at least 20 years for the offense. At least 20 years. So when you were talking about the diminution credits and all of that in 17, no. The bill says on page 6, lines 1 and 2.
But that goes to my point. My point is if they're at least 20 years, then they haven't been getting the credit for the good behavior as it is.
No, that's not.
That's not true. So you could still have racked up all the dim credits and be eligible. No, I mean, so the senator's right. The bill calls for a minimum of 20 years served, regardless of dim credits. You could still get those dim credits and be eligible for other options through other pathways. But for this mechanism, you have to do at least 20 years.
Jamie, I think this is a question for you, sir. So on page 7, lines, line 27, it says the court may impose any other conditions of release necessary to promote victim safety. So my question is victim safety defined in statute?
Yeah, not that I'm aware of, and that would be applicable. My sense is that courts would give that whatever plain meaning they saw from that phrase. Just
Do you
what
think-
they envision to being necessary to keep the victim safe.
Okay. Do you think from a plain definition or plain interpretation of that, would that include the mental health of the victim? Is it just
well,
physical? Is it
I
mental?
think-
Is it?
I think that would be peace of mind, which is the phrase that occurs right after it.
Right. I guess, and that was and I guess my third question, which has to do with the peace of mind, is that, isn't that subjective? So if it is subjective, are we going to put in feelings? Because that's what subjective is you feel.
Yeah, I'm not really sure how to answer that, Senator.
Yeah, I just don't understand why that's there then. If we don't, if in the law, why can't, and I know you didn't write this exactly yourself, so it's not you, but I just said, why is it in there if it's really subjective and it's more based on feelings? I don't know if it is or not.
I would venture the guess that this is an attempt to ensure that we are still keeping victims centered in this legislation. Again, this bill is really about mercy and grace for someone who has been incarcerated for at a minimum of 20 years, who has shown or demonstrated that they have rehabilitated themselves. And so, but, and again, it's just a second look. Judges aren't being forced to release anyone. I would just, if I'm a judge, I mean, if I felt or believed, or if things were demonstrated that the person had not been rehabilitated, you're going to remain incarcerated. I've given you a second look. I'm not letting you out, because the foundation of all this is ensuring public safety. I would pose, if I'm a judge, again, you're gonna have victims come in. They're gonna say whatever their piece is. This gives the judge the ability to say, you know what? No, we're not going to. I mean, that's my read of it.
Okay. Well, granted, and maybe my question was not as clear as can be, but your answer to me was about the person who has been incarcerated. But if we've plugged this in to look out for the victims, your answer was about the person who has been incarcerated, not necessarily the victims. And is there a way to expand this that Senator Folden made a comment that he didn't think that it was a bill for victims, but it almost like if it's subjective, if it's just allowing the judge to have his feelings put into it, is there any way we can put language in, Jamie? Is there anything we can put language in there that maybe strengthens that, or is there where we can point to somewhere else in the code that has to do with victims' rights?
The only thing I can think of, Senator, is I'd have to take a quick look at maybe peace order or protective order statutes to see if maybe
Peace
that
order.
might have language that might be in line with what you're thinking. Off the top of my head, I'd really need to look to find language. And I guess is your intent to find
I mean,
maybe
I would
more?
love to be able to find something for an amendment, or, I mean, it may be for the floor if this thing's gonna go through or whatever, but Am I onto something? I mean, I really do believe that, we've got to look at both sides of the coin on this and take into consideration the victims. And if it's not clearly defined somewhere, then it needs to be defined somewhere. It can't be just left up to the feelings of a judge to define exactly what is necessary to promote or peace of mind. If we've not defined them, how is that not subjective, and how are we not in the same quandary?
I will say that sorry, I'll defer, but I will say that the victim or a victim's representative can always, and under this bill, can submit a written statement, a victim impact statement regarding the impact of the crime and the proposed sentence reduction. And the bill also requires, now this is usually a term of a condition of release or parole anyway, but the court, this is always like an option, but under this statute, the court shall order an individual to stay away from and refrain from contact with a victim and a victim's family if the individual is released unless the victim requests otherwise. That's standard anyway, but this puts that into law. So, you're balancing, obviously the victim and their family will be notified, and this is another time that they'll be notified, but you are inviting them to the table. And I've also, in speaking to people that do this work, the attorneys tell me that these impact statements are carry outsized weight, and as they should. And so if a victim adamantly opposes to someone's release, I'm told that it is practice that those statements are accorded significant weight in the decision-making process. Senator Sidnor, and then I want to go back to Senator McKay.
No, you actually pointed out what I was going to point out, so I stand down.
If this bill gets passed, how many times is the victim family going to be impacted? I'm sorry? Re-victimized. And how is that fair? I mean, how does, and to be perfectly honest, I mean, I guess it's a policy choice, but I have a hard time re-victimizing people multiple times when it seems to me the system already has the ability through, which I hope we will do geriatric, which I hope we will do medical. I mean, I've showed my support on those type of things, but I don't understand why this is, I don't understand why this is here.
To respond to your question, I believe if you look beginning on page 7, section 3F, it says, if a court denies or grants in part a motion to reduce the duration of a sentence under this section, the individual may not file a second motion to reduce the duration of that sentence for at least 3 years. Point 2, if a court denies or grants in part a second motion to reduce the duration of the sentence, the individuals may not file for a third motion to reduce the duration of that sentence for at least 3 years. 3, with regard to any specific sentence, an individual may not file a fourth motion to reduce the duration of the sentence. So that lays that out.
Along the same parallel of any other type of parole? Or is that putting a layer on it? Because if it's on top of it, I hear what you're saying, but if it's running in the same layer, re-victimize, 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 I mean, at what point? I mean, I don't know. I'm not an attorney. I just kind of look at common sense, and I don't understand why this is here. So the answer is they could be. So that provision that's in there to protect the victim from being re-victimized doesn't really take in consideration the other lanes that are available for that incarcerated person to get parole.
That's true, there's several other avenues.
Yeah, I don't know at,
Senator West, go ahead.
Thank you, Mr. Chair. In response to the concern expressed by my colleague, Senator McKay, remember I was the original sponsor of the Juvenile Restoration Act. And at that time, with respect to, it will only apply to people under 18 years old who committed a crime when they were under 18. This now extends it for 18-year-olds, 19-year-olds, et cetera, until you're 24. I think this is the most problematic part of this bill. And I have expressed concerns all along about the number of times that people can come back. I don't have no problem with the juveniles, because I think a person is a fundamentally different person 20 years later after you've turned 18 and now you're approaching your 40th birthday. I know I was a different person in my late 30s than I was in my teens, and I suspect most people are. But now we're talking about people who are fully mature, up to 24 years old. If someone were to propose an amendment to change the third look back and said you can't do it until 5 years have passed, I could support that. Seems to me you get one after 20 years. You can come back a second time after 3 more years. But if someone were to propose an amendment to change this to say the third look back couldn't occur until 5 years after the second look back, I could support that. Even as I told the advocates for this when they wanted a broader bill which would cover people older than 24, that I could not go with it unless the look back periods of time were 5 years in length. So it seems to me that such an amendment would sort of transition between what I could live with for kids under 18, which is 3 look backs at 3-year intervals, and what I would be prepared to consider for kids, for older men, mostly men, some women, I guess, but mostly men, look backs at 5-year intervals. But no one has proposed that, and if it got proposed on the floor, I would support such an amendment. But it hasn't been proposed at this time, so it really isn't before us for consideration.
Thank you. And really, philosophically, I think some of us are probably just at different ends of the spectrum when we're talking about dealing with someone who's in this position. But one of the things that I wanted to point out, sometimes we kind of paint this broad brush about victims and their views on these kind of things, and victims and feeling re-victimized. But just for the record, there was a survey that was done. It's called Crime Survivors Speak, the first ever national survey of victims' views on safety and justice. And I just wanted to just note a few of them, just again for our record. It states by a 2-to-1 margin, victims prefer that criminal justice system focus more on rehabilitating people who commit crimes than punishing them. By a margin of 15-to-1, victims prefer increased investments in schools and educations over more investments in prisons and jails. By a margin of 10-to-1, victims prefer increased investments in job creation over investments in prisons and jails. By a margin of nearly 3-to-1, victims prefer that prison makes people more likely to commit crimes than to rehabilitate them. Let me repeat that. By a margin of nearly 3-to-1, victims believe that prison makes people more likely to commit crimes than to rehabilitate them. By a margin of 7-to-1, victims prefer increased investments in crime prevention and programs for at-risk youth over more investments in prisons and jails. By a margin of 3-to-1, victims prefer holding people accountable through options beyond prison, such as rehabilitation, mental health, treatment, drug treatment, community supervision, or community service. I've said to a number of people, I wouldn't want to spend one day in prison. I can't fathom spending your entire adult life incarcerated. And again, I think what it comes down to is, what do you believe prison is for? I mean, we have something that's called the Department of Public Safety and Corrections. So the idea is that the Department of Public Safety and Corrections corrects folks' behavior, that there's some rehabilitation that happens while that person is incarcerated. This framework that is being put together, I think, assumes that the Department of Public Safety and Corrections has done what it has been charged to do, which is to correct criminal behavior that was unacceptable, which is why the people were then incarcerated. And it gives that person who's been incarcerated an opportunity to show that they've rehabilitated themselves, come before a judge, and allow that judge to make that judgment. Again, if I'm a judge, I'm not letting you out if I feel that public safety it could be endangered by you, but that the public could be endangered by your release. I would not want my picture all over the news as that judge who released that incarcerated individual. You're going to remain incarcerated. But there are many men and some women who've done some awful things in their youth who are not the same people. And this framework that we're trying to set up allows them just another option to show that the Department of Public Safety and Corrections has done what we intended it to do. Thank you.
Thank you very much. Mr. Chair. I listen each year intently to people like Deborah Haskins, whose son was almost like my godson. His father and I, before his father passed, we went through everything from college, seminary, blah, blah, blah. She came down, she is a victim, and all victims aren't the same. She came down asking for this bill, asking that we can show mercy. We are one of the only a few countries in the world for whom incarceration is the answer to everything. I know from experience, people do change. And all we're asking for here is to have someone to look and to determine, did they really change, rather than saying, everyone fits the same pattern, throw away the key and say to hell with them. I think that this is a fair bill. I think we keep talking about trying to work our way away from being one of the only places pretty much in a nation of civilized nation that for whom everyone, no one deserves a reasonable, I know we say, well, we give parole, we give this, but reasonable. Either the system is doing its job or not. We're either rehabilitating people or we're just a punitive system. It's got to be one or the other. But when I see people like Deborah Haskins, and I see them all the time who are saying, yes, I've been hurt, yes, my child has been taken, not, and don't speak for me, because she's saying, this is where I am on it. I think most of us know where we are on this bill, and all the talking in the world is not going to change anybody's mind. And my last statement is, if we are not coming back to vote today, can we at least vote this bill out, because people know where they are on it. Thank you.
Thank you, Mr. Chair, and thank you, everyone. This has been a really thoughtful discussion. Just wanted to pick up on Senator West's comment about, the JRA, and to focus in on the group that we're talking about. This really is an extension of the JRA, because we have learned since the JRA about a lot more about the brain development and about the fact that the brain continues to develop and the prefrontal cortex that's responsible for impulse control and decision-making isn't fully formed until 25. And so that's why this bill, in my mind, is an extension of the JRA and is really focusing on these kids who haven't fully formed the impulse control and decision-making that you have post-25. Thank you, Mr. Chair.
Thank you, Mr. Chair. Just to close the loop on that, 8 years old is recognized the age of responsibility. Kids know by 8 years old the difference between right and wrong. We can sit here and make nice little comments about how, 18 to 25, they're still growing, but we allow police officers to be enforcing laws at 21. We allow our troops to go overseas and die for their country at 18. So I don't agree. And speaking of troops, I heard my good friend here from Prince George talk about Ms. Haskins, and she shows what Senator Sidnor was talking about with mercy and grace. But there's other people that we're forgetting about that, then let those people come and be the ones that are the petitioners. If they want to do that at 20 years, they feel that their ability at that point, that they can do that with dignity and grace or mercy and grace, let them ask for that. Let them be the petitioners to let them out. Because I can tell you, Miss Dawn Collins, whose son was murdered, a second lieutenant in the Army, going to an HBCU at Bowie University, comes down here every chance she gets to advocate for her son that no one gets released because he was murdered by a follower of white supremacist ideals. A person shouldn't get out, shouldn't get a look back. Took a life. So, when she talks about God has been gracious in the midst of grief, that she was able to establish a foundation in honor of her dead son, who should not be dead. She can't get him back. Let her find that grace and mercy if she so feels in the future and be that advocate. Don't force it upon her that she's got to feel a certain way, because we've done enough of that. And when she comes out and this bill would undermine the small justice in the loss of her up-and-coming second lieutenant son, going to make a difference, told his mother the world would know his name. Well, we do, but not for that good reason. We know his name because his parents come down here and advocate on his behalf because he's no longer here. They're grieving. We know that she's talking about her son's murder and uplifting her son's legacy means keeping convicted murderers behind bars to complete their sentences as the least bit of consolation for the upheaval, grief, and violence that her family has had to endure since the murder of her son. And here she is still grieving, recovering, and trying to make meaning out of the events that have forever changed her family's life. And we're talking about saying, well, you're 18 to 25. You really don't know what you're doing. You knew exactly what you're doing. You took a life. You killed somebody. 8-year-olds know that. So that is not okay. So where am I? Jamie, I'm going to ask you because I don't know specifically. I know that there was some modifications made for sentencing guidelines for juveniles, 16, I think, to 18, or 16 and 17, that get life sentences. They could no longer be sentenced to life without parole, but they could be sentenced to a life sentence. Is that correct?
So that was part of the 2021 Juvenile Restoration Act.
Correct. So,
right. So there's no mandatory minimum. Well, there's no. Right. It's not mandatory, the minimum sentences that are
so
in
16 and
statute.
17-year-olds, there's not mandatory minimums. I'm saying, can they be given a life
no
sentence?
life without parole. So
can they be given a life sentence?
They could be given a life sentence.
In the legislation, does it allow for them to have that look back at 20 years?
If you have a
for murder.
For murder, yeah, I wouldn't.
No, it doesn't.
The 16 to 17.
It doesn't.
It
so
would not
this bill
forward.
this bill is for 18 and 25-year-olds who are adults, who have adult minds. The state and the country has taken a stance that 18-year-olds, you're old enough to serve your country, to die for your country. At 21, you're old enough to go and be a police officer, enforce the laws of the land, take away people's freedom, incarcerate them. If you're 16 or 17, which of any of the group, if we look at 16 and 17 and we look at 18 to 25, 18 to 25 should never be even in this discussion. If we're going to look at any of this group, 16 and 17 is right now excluded from this measure.
No, that's right, and Senator West brought that up as an amendment. I think that's something that we're looking into supporting.
But that's
next
not.
year as he visits. I do want to make sure. I want to get Senator McKay in here, and then Senator James. We move this along.
Thank you, Mr. Chair. With all due respect to those who have pushed back about, we've already made up our minds, we've already know where we're going to be, and to use the statement that we are not giving these people a chance. In the testimony that came from Scott Schellenberger, there's 13 different ways that they're getting a chance. And when I asked my question, was this going to eliminate those chances, or are they a dual path? So we're not giving a second look, we're giving multiple. And look, I believe that we are in the business of correcting and rehabilitating people, but not at the expense of increasing the amount of times we're going to re-victimize. If this testimony is correct from the state's attorney from Baltimore County, if this is correct, that we already have 13 other ways. If we didn't have that, then yes, let's go ahead and create this ability. But it's already there. I just don't understand why we're not focusing, why this is more important, not more important, but why the focus of this debate is on this one, not geriatric or medical parole. Thank you.
Thank you, and just want to make a few comments first, and then I want to just address brain development, which I read a lot about and studied in college. But listen, it's true that the brain continues to develop up to 25. I hope the brain develops throughout your lifetime and we get a little wiser. But please don't misunderstand the data. And if you really read these reports, the scientists will tell you that they are not speaking about understanding the difference between right and wrong. So that shouldn't be overstated. And even impulse control, if you murder somebody or brutally beat them, this is way beyond an impulse. So to me, that is not a cogent argument for, that you can't hold people responsible and that they're not adults for what the criminal system, which is imperfect, is trying to determine. And as to Senator Senor's study, what I don't read in that study is how people feel about what I'm most concerned about in this bill, which is murder and violence. I am sure I too would share some of the ideas in that report about I want rehabilitation. I don't want jails to make people who had one offense turn into hardened criminals, and I think there should be a lot of rehabilitation. But where I'm struggling with this bill and the idea of a second look is in the arena of murder, which is irreparable, and I have some understanding of this. And the victims, this isn't just re-traumatizing. These victims are in a lifetime of hell. And it's not just the victims. I mean, it's not just like a mother of a child. It is if the person killed was a parent, that's a lifetime for those children. And it is generational. It goes on and on and on. And there is no second look. There is no second chance when you take a life. So I feel like this kind of bill, if it applies in that area, is diminishing the loss of life in a way that it's incalculable to me. So that's where I'm struggling. I could probably support this bill if it took out probably murder, I can't imagine some of the violent crimes that are in here. And if we did it incrementally, and there was data and studies to show, that rehabilitation and second look would work, and I think it probably does in non-violent situations. I do. But in violent situations, particularly taking life, that's where I think it's a bridge too far. So again, thank you very much for letting me speak on this. And as I understand it, we are going to include people that all crimes of violence are in here outside of child, right? All crimes of violence.
So look, this
and
is-
all taking of life.
That's right.
Okay. All right. Thank you.
Thank you very much, Senator James. I appreciate the contributions. Look, this is why this is an extremely tough committee at times, because we deal with these issues and there's no clear demarcation line for some of these things, and so it's tough. And so with that, I'd like to,
Just have one last.
sure. Okay, no, go ahead.
Senator James just made me think, Jamie, for crimes of violence involving domestic violence, where the murdered person is a spouse, is there any difference in that sentencing guideline?
I really couldn't comment.
Are we
on
just
the-
saying a
the
murder's a
guideline.
murder and, you murdered somebody? Or are we talking about, are we giving any consideration that those that have been traumatized, being beaten and repeatedly, or a child,
Yeah.
and then they are, they're in a child, because I guess that would be covered under it. I don't know. I'm going to ask. But domestic violence, where there's the continual control, which ends up resulting in death. So leading up to that, there's normally a series of serious assaults that have happened prior to that, historically. And then if it's a child who is one that would be entrusted to this adult, is there any language in this that covers that as being excluded?
So other than the life without parole and the sex offenders,
So no.
my interpretation is that it would apply to
That they would be
anybody
eligible.
that isn't in that category.
They would be
those two
eligible.
categories.
Okay, thank you. Thank you.
But just with your scenario talking about domestic violence, there have been people who have been victims of domestic violence who have murdered who would be eligible for this as well.
Vice Chair Waldstreicher.
Yes.
Senator Sidnor.
Yes.
Senator West.
Yes.
Senator Muse.
Yes.
Senator Folden.
No, and I'd like to explain my vote quickly, or just make a comment. The person that is abused and gets murdered or murders their abuser, they're more than likely one of the ones that's going to get that 12 or 15-year sentence. So while, yeah, it's nice to fancy and free and close it out and say, well, they're eligible also, but until you're in that position of being constantly abused and seeing them firsthand, these women get abused, and how they have no other outlets, no other recourse. They didn't ask to be abused, and they certainly didn't wake up one day and say, you know what, I'm going to go and murder somebody in one day of my life. It's someone that they loved and cared about and has taken advantage of them and beating them. And they did the most terrible thing that anybody could be asked to do or be put in a position to do. So yeah, they should have a look back. No.
Senator James.
As I said before, I have great sympathy for a situation where a second look would be beneficial. And I think there are some circumstances, but I think this bill is remarkably too broad, but particularly in murder and taking a life for which the family will have forever. No second chance, no look, but generation after generation of extraordinary harm beyond anything any of you can imagine. So the answer is no.
Senator Henson.
Yes.
Senator Love.
Yes.
Senator McKay.
I'd like to explain my vote. we all demonstrate grace to each other in this room. For all intents and purposes, we all have our own stories. And not to put one story against another, but I demonstrate in who I rent to, who I employ. I am a second chance guy. I do believe that I vote that way. And there's no doubt about it, I believe that this particular bill is going to go down heavily one-sided versus the other. And through my questioning and through the questions that I've had, is trying to take a middle balance approach. We've heard that we need to give them a second chance, but the evidence shows they're given multiple chances. So I'm a no on this.
Senator Charles,
Yes.
Chairman Smith.
Yes.
Bill passes 8-3.
House Bill 853 passes 8-3. All right, we'll see you on the floor.